Okay, I'd like to welcome all of you to the discussion on IT policy. And this is John Redmond Schaefer and Andrew Kite, and they are with Heil, Royster, Volker, and Allen in the Peoria and Chicago offices and take care of local government law, representing townships, road districts, fire districts, and so forth. I'll let them start.
All right. Well, good afternoon, everyone. How are you?
Good.
All right. Well, that concludes our presentation, and we thank you for coming. All right. All right.
You said 14th floor?
14th floor, 5:30. Yes. No, seriously, thank you all for coming. This is round 2 of the presentation we gave earlier today, and it's a topic that we continue to learn about. Information technology is something that 10, 15 years ago was a concept I don't think any of us fully appreciated. And today it is a way of life we wouldn't be able to live without. And so what we have been tasked with doing is somehow explaining things from the legal side in terms of what considerations should you have. I'm sure at least, I'd say a good number of you either have a website here, have a social media presence, probably have a computer or a smartphone either on you or at your office. And how in the last 10 to 15 years that has gone from the mimeographs and the telefacsimiles all the way to what we have today. Hopefully in the next hour we will try to bring it all together for you on how you leave today and handle all of that technology. So with me today again is Andy Kite, and between the two of us, don't hesitate to interrupt with questions. We like that. Keeps us on our toes. And that being said, let's go ahead.
So one of the big issues that we get, or one of the things that comes up from time to time, is what is IT, or what is information technology? When John and I started, John started probably 10 years ago.
Yep.
I started about 12 years ago at the firm. And at that time, we were just getting computers. And it was a very small amount of information technology that was out there. And at that time, all of our files were hard files. And so much like your township, our law firm has evolved over time, but all of our files were hard files. There may be some information that was kept on the computer, but if you want to go look at a document in a file, you had to go find the file on this big wall and then pull down the file and find the document you were looking for. And in the grand scheme of things, that really wasn't that long ago. Today, everything is almost entirely online or on a computer system saved on the servers. And so oftentimes the question that we get when we talk about IT policies is the clients say, well, what is IT? What is information technology? And over time, it's really become almost an all-encompassing definition, to the point where now we're talking about what's not information technology is the paper or the tangible evidence that might be sitting in your office. But for you guys, your township, it's probably the paper is not information technology, and everything else probably is. If it's on a computer or stored electronically, if it's an email, if it's a PDF document, if it's a Word document, if it's on your computer, or if it's microfilm even, it's probably considered information technology somehow. And so everything from your servers to the cloud storage to the software that is running or helping run your township all becomes into that definition of information technology. And so why we care, or what's important to us, involves a number of different things. But one of the first things that we care about is breaches of your data. Whether it be someone purposely going in and stealing the data somehow, or just losing it somehow. All of those things become important to us as your attorneys, and consequently to you as well. And we also have privacy issues regarding either employees or constituents, things involving general assistance, for example, all become very important for us and for you in terms of how we deal with information technology, how we secure it, how we have policies regarding it. And one of the most important things, the way things have changed in the recent past, is how your finances are kept. 20 years ago, 30 years ago, finances were all kept in a book. Today, it's all electronic. It's all on your system. And if you're hooked up to the internet, that financial data is subject, or potentially at risk, if you are not saving it, backing it up, that kind of thing.
Mm-hmm. And another aspect of the finance is you guys, sitting there going, well, how am I going to pay for all this? you know, we're not here today to tell you that you need a server room. We're here in a very fortunate manner in that we have an IT department at our firm. We know that's not the norm. We know that township supervisors, highway commissioners, clerks, all you name it, half of the time they're wearing a second hat as the IT department, making sure everything works in your office. And so unfortunately, we can appreciate that budgetary limitations are in place. And if you want to make upgrades and you want to provide efficient electronic services for your constituents and your office, it costs money. And so whether you decide that you want a new laptop or you decide that you need a new photocopier, because again, think electronic. This is all going to be stuff that's covered. It's okay. If you need to do this, you can do it in a step-by-step process. You're going to hear things today that some of you may say, I don't want to upgrade anything. I don't want a website. I don't want anything because it scares me to death. That's not the point. If you stay focused on information, transparency, making yourself available to the constituent, that's going to help us all in the long run. And so if you've got a budget for electronics and technology already, good for you. Now you can throw it in commodities, contractual services. Maybe you have an IT company that comes in and fixes your computers or your copiers and the like. What's important is if you look at the next slide is that even if you've come up with a budget and even though you've forgotten and we're in the middle of the year, don't forget the Illinois Municipal Budget Law allows you to amend your budget. So if you're short a couple bucks here or there and you can get away with an intra-fund transfer of less than 10% and you don't have to redo the process, great. If, however, you're running a little short and you got to bring a whole bunch over, say you have everything crash on you electronically, it's okay. We have the procedure to do it. Now, of course, there's the follow-up question is, do I have the tax money to do it anyway? But I hope that you realize that in the end, as long as you're doing two things, you're following the municipal budget law, and you're not moving things out of restricted levies, okay, I hope that phrase means something to you. You're not moving funds out of GA or IMRF or anything like that to help pay for it. We can hopefully find a way to help you in the event you need electronic repairs.
So our office has, for example, an IT department. Is there anybody here that has a full-time IT department in their township?
We had a couple in the
Very
other
few.
room.
Yeah, we did have a
actually
few in the
did.
other room.
I was surprised.
And those are the lucky few that have an IT department that's always on call. Our IT department, for example, deals with everything from our phones to upgrading the software to setting up our computers. Oftentimes, townships don't really have that luxury, do they? I mean, they're doing that all on their own. And we sometimes get in a scenario or clients ask us, well, who do we go to about IT questions? So I've got IT issues that may be beyond your control, and we have a few names of people, and if you stick around, we can give them to you, depending on where you are in the state. But and they're good to have on call or a good resource to have. But partner up with an IT, computer people that can help you out in times of need, particularly in emergencies. You know, things crash, and you're trying to get the budget out or meeting notices or whatever. You know, you got to get them out relatively quickly. But they deal with everything from our phones to right down to the software and the servers that we have in the office. And you guys may not have servers in your office, but you may be dealing with trying to retrieve data from a server.
And we can't lose sight of the fact that it's not just you, it's your employees, it's both of you, it's everybody who touches any piece of electronic equipment in your office. Could be the public that comes to your meetings and uses your Wi-Fi to get onto your stuff. I mean, that's completely within the realm of possibility that they are going to be involved with the day-to-day use of the IT. And so what are we going to do, which if you saw the title of today's presentation, what are we going to do to cover these types of activities? Because there are so many things that could be covered. But what's the most important aspect of that? Protecting your employees. Again, remember, we're going to talk about privacy rights and the like. But also the taxpayer dollar. It costs a lot of money to bring in the equipment. It costs a lot of money to deal with a privacy lawsuit. It deals a lot more money if we're talking about wasteful spending on machinery that you don't need. And it comes at a cost, because if you're not providing secure and responsible electronic capabilities, all of that adds up so quickly.
I'm the slide guy, by the way, so I hit the next slide.
I'm trying not to say slide when it's my turn. Security. Data breaches happen every day. And it's not just Well, Heil Royster hasn't had a breach as far as we know. We get warning emails say, don't open this email if you see it. Please don't, because it's going to be a problem. But again, we have an IT department that'll warn us for that. I don't care if you happen to pick a particular fruit company, since we're being filmed, I don't want to mention a name, you know, they run the risk of getting breached, and their cloud, so to speak, getting breached. There are named huge multinational corporations that have data breaches every day. How many of you received a notice from your health insurance company saying we've had a breach and we're supposed to put you on notice that your information could potentially have been out? Exactly. And so there are state and federal laws that penalize those people that have breached the wall, come over on the firewall, come, you know, put a virus into your system. But that can also be a problem for you. As Andy said earlier, general assistance. What kind of information you got saved there? Health information, the same idea. Online bill payments, not as common with townships, but it does exist. Water bills and the like. Some are doing that in the state of Illinois. Well, that can mean credit card numbers, and that can mean those get hacked. And so in the end, you may have notification requirements that are triggered, but with state and federal law in place telling you, that's why we're trying to do everything we can to make it as secure as possible. We're going to try to give you some solutions as to deal with that and the potential liability as we move forward, but it's important to identify those security considerations now.
So most of my world is dealt with, or I deal with oftentimes with lawsuits. And one of the issues that comes up from time to time is someone has hacked into your system, and what's your liability, or what's your potential, what are you potentially on the hook for? And as John said, you may have some very sensitive data on there. Some of it might be someone's personal financial data, but more likely what you're to have, particularly with the GA setting, is stuff related to someone's personal health information, for example. And so how do you help prevent yourself from having some sort of liability? And one way is to consult with an IT professional. It's not easy to do. Sometimes it can be expensive, particularly depending on how much work or back work has to be done. But at some point, you're just going to have to do that if you don't have or have not consulted with an IT professional. And the reason I say that is you can't go it alone. If you're in the course of a situation where data's been breached somehow, you want to be in the position where you say, we consulted, we did everything we could to try and get somebody, professionals in here to take a look and secure the system. But with that being said, there is no system that is absolutely secure. There are huge corporations getting hacked every day that have literally hundreds of people on staff dealing with IT issues. And so nobody is immune from it, nobody's safe from it, there's no measures you can take to absolutely prevent it, but there's measures you can do to help put yourself at ease and help reduce any potential liability that you may have because you didn't consult with an IT professional.
All right.
And go ahead.
Well, and one of the biggest areas that we're seeing growth, I'm shameless promoting, I guess. I mean, I'm very blessed. I'll just throw that out there. But the point is this. Social media is a godsend, but it can also be a problem because you have a situation where security is becoming a new facet and social media is becoming a new vehicle for people to get at you. They're using it as an opportunity to entice you to click on a link that will now get them access to your account. There may be something that intrigues you. Oh, this looks like an interesting article. Now all of a sudden you say, someone calls you and said, hey, why are you sending me a friend request? I thought we were already friends. And what had happened is someone has set up a mirror personality for you, a mirror account. So if you look at this one in the next slide, to give you some examples, you know, and then next one, please. Thank you. Think about what it can do for you. Don't lose sight of the advantages of the social media realm. Communications, road closures, meetings, special meetings, important announcements, a party, holiday party, job fair, health insurance fair. In addition to traditional ways of letting people know, I get it. I see some of your townships posting this information, and kudos to you for doing so. It's free to sign up. The price is right, is it not? But we can't overlook, obviously, some fundamental publication requirements. I'm not telling you to put notice of your annual or special town meeting on Twitter and think that's good enough. It's not. But all things considered, it can have problems, and again, we'll address those, but you also have benefits for using that social media.
And I mean, like, it's one of those scenarios where, like it or not, we're just moving into an age where more and more things are found online as opposed to in print. Mm-hmm. And, a good example is we had, at least in our area, we had a lot of townships had to close roads during the last winter. during certain time frames. Roads had to be closed just because they weren't passable and it was dangerous for somebody to go down them. Obviously, you're posting signs about those roads, but another way you can get the information out quickly is to put something on Twitter or whatever the township's Facebook page or whatever social media site they have. Now, to backtrack just a little bit, there are a number of issues that you face though with having an official Twitter or an official Facebook account. And a couple of those are related to how you're mixing, or if you are mixing personal and official business. It's always separate. So whatever you have going on in your personal life, you need to have an IT policy that is separating the official work of the township from the personal views of perhaps a township employee that may be posting things on Twitter, for example. So you need to have policies addressing those things. Also, political, if someone's running in a township office, what would be improper? One thing, posting, requesting political contributions to your campaign if you are posting on the official township page, right? Now that's a pretty clear example. Pretty clear example, but it's been seen, and that happens. I mean, people do that. So those are some highlights of areas that you need to be mindful of.
And so the bottom line is this: how many of you have an IT policy? That's okay, because I'm glad you're here. All right? I guess we're in the right room, right? Let's look at it that way. The IT policy itself is what you make of it. I'm not asking you today to create something that fills a 3-inch binder. That's not the point. The point is to address some of the most basic needs and problems that we've found. Again, this is an evolving science, but we're doing our best to make sure we address some key points. Who does it cover? Well, we know it's going to cover employees. We know it's going to cover independent contractors, agents, computer users. These are terms of art that we can talk about in a little bit, but also third-party vendors who may come in and start utilizing your equipment, not for their own personal gain or their own company's gain, but to have their hands on your stuff trying to fix it. So again, that's the general concept of who this is going to cover. And if we look through an example, your phone can access multiple Twitter accounts. And if you have a third-party vendor who was trying to post on his own Twitter feed how he did not really enjoy Detroit driving, but accidentally put it on a major automobile manufacturer's Twitter feed, we've got a problem. So I won't give special credit to anybody who can guess what is behind the red box there, but you get the idea that this is a problem. And if we've got someone utilizing our equipment or maybe doing e-newsletters or email blasts for us, and something like this gets out, we've got to have a policy in place that says, whoa, we're terminating our services and our relationship immediately because this is inappropriate. Is this still me? Okay. Yeah. Apparently I'll keep going. So do I need one? We're going to say yes. And you're going to say, well, John, I know that in the township code that if I have less than 5 employees, I'm not really have the obligation to trigger all those rules and regulations for my employees. Our response is, we don't care. And we say that with a nice smile on our face because we're trying to protect you. It's the same reason why we would go to bat saying you got to have a sexual harassment policy, an anti-violence policy, and several other types of policies that it doesn't matter how many people you have, because when the federal government comes to your office and asks to see your sexual harassment policy, they don't care how many employees that you have. They care that you have an employee who's made an allegation of sexual harassment, and what are you going to do to fix it? And that very first question is, where's your policy? I want to see it. So the same can be said for information technology because we're trying to protect employees. Don't lose sight of that. Yeah, we're covering our own hind ends. We had a guy who kept saying CYA during the prior presentation, but it's a good concept that, yeah, we got to make sure we're protected, but don't lose sight of the fact that you're trying to protect your employees as well. Obviously, we're going to cover the township and road district as best we can. Some road districts don't have as much technology, but it shouldn't matter. This is one of those instances where it's probably pretty good that you all work together. We're a proponent of you working together anyway, but I know that in this particular concept, there's not much difference. I don't care that your duties and responsibilities are sometimes different. Where IT, it's all the same. And should it cover personal official use? Andy touched upon that. Absolutely. We got to make sure we clarify who can do what on what accounts.
when you are going through the phases of adopting a policy, the first consideration is consulting with an attorney to get one done. Doesn't necessarily have to be us, but great.
We're okay if you do, though.
But the point here is that you need to consult with someone early on in getting it drafted. And one of the primary things is you're going to reserve the ability to change the IT policy, revoke the IT policy, or add new definitions. And the reason that is because information technology is changing as fast as we can write the policy. So 10 years from now, there may not be a Twitter, there may not be a Facebook, and so all of that will need to change and be revised. But as you go along, it's ever changing. When we started the talk today, there's probably been changes to information technology that are going on as we speak, and so we always just have to be alert to those types of issues. In the terms of the definitions that you're going to have, how you define these things sometimes will depend on what type of township you have in how sophisticated things are. There are some townships. Does anybody here not have a computer in the township? We have a few.
There's still some.
We still have a few that may not have a computer at all. And so your information technology is different than the information technology that someone else may have. And that's another good reason why you need to keep open and reserve the ability to be able to change your IT policy as time goes on. The definition of users is another area that I want to touch on, and that is users in their professional capacity as a township employee, and people that are allowed to use the computer in the sense that they may be able to use the computer for their personal use, even though it may be township computer equipment. Some townships allow that, some don't. I think we generally suggest that you don't allow personal use of a township computer, although how hard is that to regulate? It's almost impossible.
Right.
It's a very difficult thing to be able to regulate. So we have to be careful about how we're defining these users in terms of what's permitted and what isn't.
And so the policy itself, as it starts to take shape, we've got definitions. We have an idea of who it's going to cover. We have an idea of basically what are we going to do on official and personal use. Who's going to have access to the official Facebook and Twitter feed? Who's going to have access to the township's official computer? Who's going to have access to all of your information technology? What is the legal accountability? Copyrights. Who's uploading, and I'm not looking for a show of hand, who's uploading bootleg Microsoft products? Who is putting things on there that they shouldn't? Who's putting a thumb drive in there without having having a virus scan it? These are things we should seriously consider to make sure, again, that you've at least created some layer of insulation and putting the employee on notice that that type of behavior is not going to be tolerated. Because when it comes down to it, it's not a far stretch to someone to say, well, yes, I put up that bootleg copy of software. Maybe the same person or someone else completely that also downloaded some very inappropriate material onto your computer. And by inappropriate, I mean inappropriate, not just illegal software, all right? Or downloads things that shouldn't be on your equipment. Again, I mentioned viruses, but again, there could be things where someone downloads, I don't know, music software, and they've got your computer so full, the hard drive so full of 8 million songs that, well, how's that going to be a functioning computer for your township services? However, in law we talk about on the one hand and on the other hand. This is the other hand. Employees have privacy rights, period. And we're going to tell you in a moment about applicants. Yeah, that's right. This is going to extend to those people who are applying for jobs at your township. Federal and state law get involved. The National Labor Relations Board, and you're saying, what are they doing with technology? Well, and the Illinois Department of Labor. These are two entities that care about the rights of those in the workforce. And it's going to have an impact as you're starting to formulate your policy. And as recent to, started I guess about 4 or 5 years ago, but the NLRB started investigating IT policies. So we already have a watchdog looking over what we're putting together, and they're actually issuing formal rulings about people, employers trying to get involved and thwart what's called concerted activity. And I think you're going to talk about concerted activity.
Yeah, when we talk about concerted activity, what we're really talking about is people engaged in some sort of collective bargaining or attempting to collective bargain. And what we can't do, or what townships or anybody really can't do, is being able to thwart some type of concerted activity into joining or creating a union. So, that's one aspect that we're always going to have to keep in mind.
And what gets interesting is the definition of collective bargaining is not necessarily what you think it is. The obvious thing would be to send an email saying, hey, everybody meet after work because I want to talk about unionizing. It doesn't have to be that. It can mean, man, these work conditions are terrible. Or, man, is it always hot in here? I just don't like it in here. Or, man, that boss is really starting to clamp down on things that are pretty reasonable behavior. The line is blurred, okay? So, again, as Andy was saying, consult with your lawyer to make sure. If you're coming up with your own language, I'm not going to lie and say, yeah, you can Google information technology policy out there, but are you convinced that it's going to follow Illinois law? Are you convinced it's going to follow federal law? Are you convinced that it's been tailored for you? You better have another set of eyes look at it.
Let's talk about, very briefly, applicants to a township position. And this is something that has dramatically changed over the past 5 years, I would say. In fact, I think this law came into effect within the past 2 years.
I think it was January of this year.
Yeah. And so what you can't do now, and what some employers were doing, and what oftentimes would happen is a new college graduate would apply to a job at a business, government agency, whatever that the case may be, and the prospective employer would say, well, we want your Facebook password because we want to see what it is you're doing outside of school, what sort of activities you're participating in. Now, of course, there are going to be, as there are on most college students' Facebook, probably things they don't want their employers to see, right? And there may be information, or there may be things on there that the employer may see and then decide that we don't like what we see in this applicant, and therefore we're not going to give them a job. Now, that may lead to things like a discrimination claim. And this actually ends up protecting a prospective employer like a township just as much as it protects an employee or a prospective employee. So what you can't do now, that people were doing for a while, is request someone's passwords to their Facebook or Twitter account or something like that. So you can't do that. You used to be able to do it. There are very few positions where you can do that, but there's almost none today.
And the General Assembly tried to address that by creating another section, also effective the first of the year. Think about what you just read. Now, you're not going to be able to get on to their personal social media accounts and the like. However, password, account information, access sought by the employer, if it relates to a professional account, nothing prohibits that employer from complying with the duty to screen employees or applicants prior to hiring. So they've tried to understand the professional versus personal nature, much just like you should in your IT policy, coming through with the idea of, okay, we understand the idea that someone leaves your employee and all of a sudden I need to know how to get in. Andy leaves the firm and I don't have access to his computer. Well, our IT department knows exactly how to get into his computer. And quite frankly, he shouldn't have an expectation of privacy in the event we need to get into his stuff if he leaves the firm. So it's a little bit different, and the General Assembly tried to address that for us.
The big point, we have other considerations regarding the IT policy, and the big point I would make here is, and this is true regardless of any type of employee punishment or discipline you may be handing out, and that is you cannot have selective enforcement. In other words, John is on a computer doing certain things, and if person X is on the computer doing certain things, and we enforce differently our IT policy as to John versus the other person, we're setting ourselves up for a potential lawsuit or some sort of liability that may be out there. And so you have to be very consistent as to how you're going to do that. Another issue that has come up and has been very prevalent in recent history is postings at work versus at home. And there's always a First Amendment right. An employee always has a First Amendment right. That right can be tempered at work to some degree. At home, if they're posting at home through their own computer on their own time, they have a lot higher First Amendment right than they would be able to do it if they were at work. Now, there's a lot of shades of gray in between. But the point is, it's very difficult to discipline someone for speech outside of their employment. So just keep that in mind. And you may see somebody have something that makes you mad as a township official, that may be an employee, but if they're doing it on their own time through their own computer, and it's very difficult to discipline them through that.
And if you're getting the idea that, it's hard to get a definitive answer out of these guys, well, it's because it's difficult for us to do so. I mean, there's a reason why the lights stay on at the firm, because you get 2 lawyers in the room, you get 4 different opinions. I mean, that's just the nature of the game right now. And especially when it's okay to laugh. I understand. I'll appreciate a good lawyer joke. But that's what's important, is that you have a situation with a continually evolving subject matter that we're all still learning, and that's okay. And to this point that you see on this slide, elected officials. I've had clients come to us and say, well, should I sign it too? I'm not an employee. Traditionally, we're going to throw the IT policy as part of the personnel or employee manual that we have together, because it's a related issue for my employment at the township. When an elected official comes to us and says, well, I'm an employee too, the public made me their employee. I respect that. I can admit that I have signed one as a county board member. I've signed an IT policy. I've signed one as an employee of Heil Royster. It's okay for you to do that. But I will say that no matter what, whether you sign it or not, you can't lose sight of the fact that I'm also bound to follow the law. Just because I didn't sign one doesn't mean I can go upload all the bootleg software or throw the thumb drive on there that's got virus issues and the like. I can't, just because I didn't have to sign it doesn't mean I have a right to invade someone's privacy. Again, I think it's a nice step, and we typically encourage our public officials to at least agree in principle to the idea of following this. And no matter what, you're bound to follow the law. So that's the policy side. And so the beauty of, again, maybe our career is that that's not the end of the ball game. We have a slew of other laws that can be impacted. And Andy is our FOIA guy, and so he's going to take you through this part.
All right, so I think we've all heard of the Freedom of Information Act, particularly in the past probably 4 or 5 years, when it was amended in 2010? Somewhere in there?
Ish, yeah.
And during those amendments, of course, everybody became very aware of all of these issues regarding the Freedom of Information Act. And there are seminars, and now we have to have the FOIA officers and the Open Meetings Act officers for every township, every public body. And so it's become more and more prevalent. I mean, if you mentioned Freedom of Information Act in a room 7 or 8 years ago, you would get a lot of blank stares sometimes. But today, I don't think that's necessarily the case. And we sometimes still get the question, though, I have a bunch of emails. Are those public records? And the answer is yes. If it's on a public computer sent to a public address, it's regarding business, it's a public record. There's a lot of electronic data that you have. There's a lot of electronic data that you probably don't even realize that you have that would be considered a public record. One thing is there's been some recent case law on this issue, and it kind of very narrowly tailored a very fact-specific scenario. And I want to caution you on reading it beyond what it is. And the case really dealt with someone sending a message, I believe it was a text message, to another board member during the course of a meeting on a personal, and it was on a personal device. It wasn't on a board provided device, et cetera. So that particular case found that those are a public record, okay? What I don't want people to walk away thinking is, well, if it's not in the course of the meeting, that automatically means it's not a public record at all. And that doesn't necessarily mean that's true. It's a very fact-specific analysis that the court did in that scenario. So just keep in mind, if you are sending a message to another official, or you're receiving or sending a message regarding official business or township business, chances are that is going to be considered a public record. Now, there may be a whole slew of exceptions that we may be able to use to either redact or prevent having to disclose whatever that document is, but all records that you have, whether electronic or a hard copy, are considered public records. Now, there may be exceptions to it, but...
And this is where we caution you, again, not to be cute. There are many people in this world who have more than one email address. One that's their official, one that's their personal, one that's their work. And I will tell you that telling someone to, hey, just send it to my Gmail, or just send it to my Heil Royster, and don't send it to my county board one, there's no difference, all right? They've sent it to you related to public business. And as Andy was alluding to, in addition to Freedom of Information Act questions, please don't take advantage of an email in which the entire board is listed to make it into a dialogue, into a reply-all situation where all of a sudden you've decided, well, I guess we can just conduct business on a big, long email chain. Because then you violated the Open Meetings Act. And those of you that have talked to us over the years about it, we tell you, you can send your board packets. Good for you for trying to do it electronically. We're all going green. Our firm is one of them. Just put, what's the disclaimer you have for your Zoning Board of Appeals? I thought that was really good.
It's something along the lines of don't reply all. You know,
Exactly. Do not reply to the sender.
Yeah.
Right. And to confuse the issue even more, again, keeps the lights on for us, Freedom of Information Act has a definition of public records, but so does something else, the Local Records Act. Now, what once was easy, and this is a lawyer's worst nightmare, by the way. We get our ties caught in the shredder. It's a terrible idea. So we send things to our file department so they shred for us. What once was easy per se is now becoming to a degree almost too easy. If you go to the next slide, thank you. And boy, it's just so easy to hit that delete key, isn't it? But it's not so. It's very deceiving. It's not so anymore because the Local Records Act. Credit to the Secretary of State's office, and a lot of the material you will see here in the next few slides, we want to make sure they get credit. If you haven't researched the issue, they have a frequently asked questions through the state archives. You can Google it and go to the Secretary of State's website or Bing it, depending. I'm not here to be biased. But the idea is this. You are subject to the Local Records Act. That should ring a bell to you. Some of you have probably had someone come out, look at your records, paper or otherwise, and issued you a certificate at the end of their review saying it's okay to destroy a range of materials dated X through Y and covering these specific categories. Any official documentary material, again, this is the Secretary of State and the General Assembly anticipating the new technology, regardless of physical form, in connection with the transaction of public business, is a record subject to the Local Records Act. So at this point, we're still running a good parallel. Anything created for public affairs related to FOIA. Same idea here with local records. But again, depending on the information contained, which we'll talk about in just a moment, this is going to include emails, faxes, instant messages, the old text message, DVDs, and it can also include your body's Facebook, Twitter, blog, and other forms of social media. So think about that. You've got a long chain of Twitter feeds. Don't be deleting it, especially because it may be subject. However, we have information that's not subject to the Act. Andy?
Yeah, so you probably have a host of communications among people within your township, particularly regarding things like meetings. There are donuts in the office. It's my favorite email. So
make sure you get to the room first before he knows.
Right. So you've got a host of these, what the Local Records Act would call transitory documents. In other words, they may be related to business, but it's not necessarily an important communication regarding the building of a new building or how to spend funds or something like that. It's merely notifying other people that there is a meeting coming up, or pick any number of what they would call transitory messages.
But the last bullet point is there for a reason. When in doubt, you have to ask. Just because it's a transitory message under the Local Records Act doesn't always automatically assume it's not a public record under FOIA. And so that's the problem that we face sometimes, is just saying, well, I've got a stack. I mean, it's not a big deal and all that. So what's important? Go through the process. Talk to your lawyer if you think there's a FOIA issue. Do not destroy the public records without permission. You've got 60 days prior to the disposal. If you've done the process before, it's very straightforward, and a credit to that office because they handle it in a very professional manner. You're going to send the certificate saying, I've got these records I need to get rid of, and then they'll let you know about whether you can proceed with disposal. Again, someone will come out and help you go through those. And it's not just because you need permission to destroy. It's not just because you can actually have a document that's actually responsive to a FOIA request, that is that certificate. There's also historical significance to it. There have been numerous historical documents found during the course of destroying public records that have actually had benefit to the community. That maybe it's an old map, maybe it's a letter written by Abraham Lincoln. There is a reason why we don't get into a hurry to destroy records. Now, we throw that last bullet point up there not to scare you, because we know sometimes things get destroyed accidentally, and we have to figure out, again, each case is different based on its facts. But I'm not going to lie to you and say there's nothing in the Local Records Act that serves as a penalty, because violations can lead up to a Class 4 felony, which, as you know, as an elected official, is tantamount to forfeiture of office. You had your hand up.
I was just wondering if in some cases, like when you're doing agenda minutes, you have electronic records as well as paper records.
Mm-hmm.
All right, now, yeah, you know where I'm going.
No, I'm beginning. We cheated. We had another prior version of a prior session, but go ahead.
Okay, well, you have to keep both sets. I mean, if you wish to dispose of them after the 5 years or 7 years, depending on which one, do you have to get, what process do you go through? I just went through and with the state, and they were just talking about, well, you get the application and you send it in, and they have their person come out and they'll log
That's right.
and everything. And well, if you're doing parallel records, for example, okay, how do you handle it?
Okay, the question for those of you that couldn't hear it or for the tape is, what do we do when we have both electric and paper versions? Okay? And I will give you two practical real-life experiences we've seen with our clients. We had a client that destroyed all of their paper copies and went to the process of scanning and putting everything on a drive. And so, wonderful. They started the process of destroying the paper records. The Records Commission said, you better not do that, because what happens if your computer crashes? You didn't have permission to do that. The flip side, I'm going to delete everything off of my computer and just print it all out and put it in my files, that way I have it. Well, what if the place burns up? And I know that that seems silly, but unless and until we have permission to destroy, and I'm not asking you to leave here going, well, great, now every time I duplicate everything, I got to do this. Big picture. The agendas don't take up a lot of room on your computer. You've created an electronic version. You've created a public record. You've printed it out. You've created a public record. Again, maybe a simple phone call can alleviate that from the state archives. But I'd much rather you make that phone call than get in the process of just automatically assuming you can delete, because I don't want a technological failure or an act of God to somehow impact that come later. Yeah, that same fire, because this was my argument, the same fire could take out in the computer too.
Right.
And what do we do? But they at least said, well, you should at least ask. John, go ahead.
If you're not in my address book, you're in my trash. I missed.
You're saying that about me?
Well.
Oh. He didn't answer that, by the way.
You're in my address.
Okay.
I missed the openthebooks.com electronic FOIA for 10 years worth of records. Fortunately, the clerk caught it. We responded. But if I don't open an email and it gets trashed, it's not public record, is it?
Okay, the question was...
I get 100 and some a day. Like,
Well, and unfortunately, the question relates to what are those instances where you didn't get the email, where it maybe went straight to your junk or your spam folder. That's a problem. And, you know, I'm glad the clerk caught it. You know, with the example you cited, I believe it went to both road district and town side. Sometimes the clerk, it was whoever really had registered as the FOIA officer with the Secretary of State. I think that's how the names got out, which is purely public information. That's not a problem. However, we got a problem that, and Andy, feel free to interject here, that if I get turned into the PAC, the Public Access Counselor, I hope you all know that acronym, and they say, and the side says, the road district never responded to my FOIA request and nobody else got it. So the clerk didn't catch it. And the Attorney General's office says, okay, let me see proof that you sent the email, which can be provided. And they go to you and say, why didn't you respond? Well, I didn't get it. I don't think that's going to be enough to get you out of eventually having to comply. Now, truth, I mean, shall set you free, right? You can say, I really didn't get it. You know, and I put a sworn statement, an affidavit together that said, I really didn't get it. But that doesn't mean that you won't get an opinion that says two things. Number one, it says check your junk mail. And number two, it says you're going to produce the records now. So I wish I could say it's okay, but nothing precludes them from trying to enforce their right under the Freedom of Information Act to get that information.
And the other one is the other day was a vote, and everybody that was all the election judges and everybody, they wanted access to our router. And so they were all playing on the internet through our IP address number, you know.
Really?
As voters, judges, yeah.
I would, well, it's a tough call because you mean in terms of election judges?
Yeah.
Yeah. So
they were
they're sitting there
there for
volunteering and
12
they're, you
hours,
know.
Oh, so they're on your internet. They're on your internet.
Yeah. Yeah, that's a tough call.
Slow turnout? Is that what I'm hearing?
I would generally say that to not allow that.
Shouldn't be doing that. Huh?
Yeah, because whatever they're looking up or whatever they're doing is going through your IP address or your router, and you have no idea, you have no control of what they're doing.
Exactly.
And so they could be doing anything. I mean, they could
They
be.
could be coming back into our computers.
Well, and absolutely. How many? We've sat in county courthouses where you pick up two Wi-Fi signals on your equipment. One of them says secure, one of them will say public. If you really want to offer it and you're willing to put forth the money, create a separate access point.
Yeah.
Now somebody else had their hand up. Oh, I got three. You're up.
I had a quick question with regards to township officials and township employees being protected. It appears that under this FOIA and the LRA, there's very minimal or hardly any protection that we have, because everything, if it's an email or a text related to township business, it's FOIAble. So, I mean, is there any protection? And if so, how much, or what is there?
You mean in terms of from any potential either liability or some
Yeah.
sort of, it's really hard to really give you a black and white answer on that, and which is a great lawyer answer for there's no real answer to that. The question really is kind of what protections do we have as an employee? And I will say this, I think generally, and I don't mean this to be some blanket rule, but generally prosecutors or the Attorney General's office, they're not really looking to punish people who have a good intention. I think if someone stole a bunch of money from a township and then took the books and shredded everything and deleted all the files off the computer, that's someone they're looking for, right? If there's someone, for example, that got an email that accidentally went into the junk mail, for example, and they can say, look, I didn't get the email, or I don't recall seeing it. I think generally either the Attorney General's office, for example, in that scenario, really isn't looking to punish someone or hold them liable. And it's a really kind of a big shade of gray in there, you know?
I had a second part to that question. So typically, we all think that, well, if it doesn't happen on township officials' time, if it doesn't happen on any type of government type electronic device, and if it's just between, let's just say, one elected official to another, or a resident to an elected official, because oftentimes we'll share our emails or we'll share personal cell phones, then in that case, we're covered. But like you had mentioned earlier, that if it's township business related, then that opens it up to potential being FOIA.
Well, the problem, and I'll interject here because I have the personal experience as well, because I may get my notice for county board meeting and my agenda for committee meetings and all this stuff, and I may, in my mind, forward it to another member who's not on the committee and say, hey, what do you think about this? And there's an evolving situation with case law where the courts are going to come down. There was a slide a while ago where the public access counselor talked about that scenario where I'm on my phone, I send a text to my buddy who's also on the county board and say, hey, did you see this? What do you think of that? And under that original opinion from 2011, the concept was that's fair game. It doesn't matter if it's your device or not. Now, since that time, the Illinois Appellate Court, I believe 4th District, I don't remember exactly, it came down and said, well, now wait a minute. We understand that there are circumstances where two guys, it's the same concept where you and I could sit at breakfast and talk about things, and we don't form a majority of a quorum, or depending on the size here, where just because we talk about it versus texting it, we're protected. Well, the 4th District, again, it was a limited factual situation, but they said we have to understand that sometimes people are going to talk. And so in that circumstance, they said if you're on your devices during the meeting, then we got a problem. And so what do we suggest? Sit down with your lawyer, make sure you guys are clear. Even if that takes 10 minutes at a board meeting, make sure everybody understands the parameters, because I was trying to practice what I preached, and when I started getting emails for county business, I went, oh my, what do I do? You know, I really have to sit there and go, okay, well, who was on that one? Okay, well, that was the county board clerk who was on that one, so she's probably got a copy of it, you know, and you do. You have to sit back, and again, we can't give you an answer to every scenario, again, donut emails and the like, but again, if we can have a policy and we can go, let's say we get called to the carpet and we have to go in front of the public access counselor and explain the situation, we can at least say, hey, we did this as best as we could, consistent with what we felt were the Freedom of Information Act terms at the time, and consistent with a policy that all of us had been following and understanding. Again, it sounds like a cop-out answer, but we're going to learn, I think, over the next few years whether that's good enough or not.
Do we have to?
You've already asked one. I'll let her go first. Then I'll get back to you.
Ladies first.
Yeah,
Come on.
fair enough.
Do we have to keep all the agendas too?
You should be keeping your agendas anyway, because for two reasons. Number one, it's a helpful tool for you to know what exactly has been going on over the years of time. Now, you could say, well, the minutes are going to reflect what the agenda had anyway. But our recommendation is that the agendas be saved. And secondly, someone could ask you under FOIA, I want your agendas, not your minutes, but I want your agendas from 2008 to the present. And if you don't have a certificate saying you can destroy those under the Local Records Act, you better produce them. Good question.
Yes.
You see, now I got hands around here, so, but I'll let you go. Go ahead.
All right, I appreciate it. It's a two-part, but.
2 parts, come on.
It's a short.
All right.
All right, but we have an employee that uses the township email.
Okay.
What happens if that employee leaves?
That's one of those circumstances, Andy, what do you think? I think that's one of those where there's no expectation necessarily of privacy if it's the official account.
If it's the official account, they have no expectation of privacy.
So, but then the township can get all the correspondence, or?
Make sure it's clear to them at the beginning. I mean, again, if you have a policy in place and say, hey, in a big paragraph with bold language that there's no expectation of privacy, if you're using the official account, the official software for official businesses, they shouldn't be scared if all of a sudden you have access. They should be scared if they're sending inappropriate or other materials, but that's not your fault. You gave them the notice that there should be no unexpected issues there. I mean, again, if Andy were to leave Heil, we have to get access to his account because he may again, he's a private employee, and I know there's a difference, but there could be 10 or 15 emails from clients that we need to know that he got.
Right. And the second part,
Second part.
Quick. Township officials, I'm talking about like clerks, the supervisor and so forth, do we need to set up this individual accounts on that same?
Why don't you go to the next slide? I'm going to tell you. No, I'm going to tell you.
Am I good? All right.
Foreshadowing. How about that? He's not even a plant, and we'll get to your questions in just a moment.
Okay.
Effective January 1st of next year, if you have an internet website, it's funny that we still need the word internet, I guess, but here we are. Other than a social media website or social networking, shall post to its website for the current calendar year a mechanism such as a uniform single email address for members of the public to electronically communicate with elected officials. Now, at this point going forward, if you have a website, other than what the exceptions there, and I personally believe even if you don't have a website, you might as well let people know how to get a hold of you because that looks good and it shows a little bit of transparency and accountability. Put a website together if you have it, fine. Because some people say, well, I don't want to do that now because now I have more mandates. It's okay. Again, we have to keep focus on the fact that we are accessible. So in this circumstance, if you do and you don't have email addresses, put one together. We were talking earlier about state, in another session, about state and federal agencies have FOIA at, and then whatever their domain is. You know, because now you know, obviously that's going to be the FOIA account. Right. Supervisor at, clerk at, assessor at, township.com. Sky's the limit is how many you want to create. The question though, and the only pitfall I would see is if a FOIA request goes to one of them and you don't keep regular tabs on one of them, be careful. So if you're going to set up one, and again, you might have to now in these circumstances, there's nothing prohibiting you, and I actually think it's a good thing that you let the public know, hey, you can get a hold of me.
If I could add one thing to that is if you have an email address that is something along the lines of FOIA at pick a township, West Peoria Township. FOIA at West Peoria Township, so that that email address receives all of the Freedom of Information Act requests. Don't use that as the
Right.
one email to communicate with everyone. Okay, so do you follow me? So if you've got one that is a FOIA address, create a separate one so that people can communicate with you on that email address for non-FOIA related purposes, if that makes
Go ahead.
sense.
So my clerk sends my agenda to me and the minutes for just to see if I have any changes or tweaking.
Mhm.
Do I have to keep those?
Isn't that like advertising for FOIAs?
So the question in the back is, what do I do with the draft minutes
Yeah,
or the
just
draft
drafts.
agenda?
Yes, but I think your clerk has it. Does that make sense? Are you saying, do you personally need to keep the email that the clerk sent to you?
Yes, do I need to keep that email that the clerk sends to me that says, this is a tentative budget or a tentative agenda for the township meeting that we're gonna have?
Right. I would say no because the clerk has it.
Somebody has to.
She has to keep it, or I have to
Somebody
keep it.
better.
You don't have to, in other words, you don't have to keep duplicates. In other words, if I have two pieces of paper that say the same thing, or that is the same document, I can throw one out, right?
Unless one is stored electronically and one in
Unless one's
paper.
stored
Isn't that great?
Then you have to keep both.
Until you get permission to destroy it.
So
Now,
then
in
with
the
this,
previous meeting, he said that if once you printed it, you had an official hard copy and you could delete what was
Well,
on
were you at our previous
the
session?
records.
No, the records
We came
retention.
from the
Oh,
records.
yeah.
Just add a session. If
Yeah.
it says copy, you don't have to keep it.
Again.
Credit is just normal correspondence.
And we're giving you the legal, our opinion. Again, it's always subject to multiple interpretations, but I would tell my clients to make the call down there and get permission and have something in writing. I'm not going to assume that something I hear today, and I'll say that even of our presentation, is going to be a good enough defense. If I think there's a question, before I start on down that path of getting delete happy, which I would love to do when I have too many emails in my account, I love to start hitting the delete button, I better be darn sure that I'm doing it the right way. Even if it's acceptable, what's the appropriate way to do it? So make the phone call before we start just assuming something we hear in different rooms is the way to go. Yes?
Regarding this new law, does that have to be posted on the homepage of the website or just anywhere?
You know, reading it out, yeah, that's just it. It's pretty vague. My recommendation would be to put it on the homepage, just because a lot of websites aren't as complex as others, and you know, I would hate for someone to say, well, of course you hit it on the, you know, drill down 6 different layers on it. It would make more sense if you could put a little shadow box on there that said, contact us for information, and there's a little link. That'd be my recommendation.
so if we have no social media, don't have any website, don't have any Facebook,
You're the poster child for the people. I don't want a website. I don't want to be accessible. No, but you're right. The way that reads, again, if you serve a population of less than 1 million that maintains a website,
which we don't,
Yeah,
so we're, okay,
yeah, stay that way.
yeah.
now that's not the spirit, John. Another question.
This involves emails.
Uh-huh.
So at our township, for example, we have individual emails for all the elected officials and all the employees at township.org. And when someone wants to go on our website to send an email to any of the elected officials, we have since we don't necessarily have offices or access to computers for the township, the emails are forwarded to our personal emails. And so
Okay.
we get them on our smartphones, and we can say, oh, John Joe Citizen is complaining about the tree being too tall. My question is there a responsibility that I have to have as an elected official to keep that email that John Joe Citizen sent me about the tree?
Well, what I would make sure is to see who else got it. And if you were the only one that got it, we have an issue. You know, we were just talking about the clerk and the supervisor exchanging emails. If it was a blanket email to all of them, to all of you per se, I would make darn sure that we have something in mind, again, maybe a policy that says, all right, if somebody gets one of these, who's keeping it? Because we got to have a record.
If it came from it sounds like it's coming from a government account and then it's going to your personal account.
Yeah.
In that case, I would say you probably already have it in the government side.
True.
And so I don't think you necessarily have an obligation to keep it on a personal device somehow.
Right, that's what I'm saying.
But make sure, that, especially if you're the only one that got it, make sure you're not deleting it from the official account.
Correct.
Yeah.
So then but the only, I think, issue you might arise for you is this, then you're then responding to the initial question from your personal account.
Right.
You follow me?
You reply.
So see, that's the problem.
Yeah.
Right.
And you may
What's the
not be,
problem?
you may not then be responding to the government account. You may be responding to whatever the private, John Q. Plumber's
Yeah.
account.
And
email
that's not
account.
going to be kept by anybody else.
And that may not
My
be being
response
kept.
will not be kept because it's coming from my personal email.
But it has.
But the problem is now you've triggered the idea
Yeah.
that you've responded to the constituent complaint as an elected official, no matter the account.
So that becomes,
A public record.
Yeah. Now, what you could do is have a policy that says any response to a citizen regarding official business needs to come from a public account. You could have that policy,
But it's so easy to do to just respond right away.
but it's easy to respond right away.
All right, I know there are a few other questions, but let's get through this last section because I want to make sure we talk about it. The world is changing, we got it. Long story short is, does anybody know what their insurance policy says from start to finish? I don't.
No.
Read it. Because over the years we've had some issues as the electronic age develops. Well, what's a personal injury? What's property damage? Can we somehow say that someone hacking into our system is property damage? Can we somehow say that hurting someone's financial records or getting into their information is a personal injury? It's a big assumption, and it's not always the case. There are sections of your policy that aren't in the general part. You've got endorsements, maybe the extras. You've got exclusions that specifically say this isn't covered. So if we look on the next slide, thank you, that long story short is, are you electronic? Where's your data stored? I mean, anything we talked about today apply to you. We got to really think about what's going to happen on the liability aspect. I can tell you that Torma is looking at how they want to address this. And I'm saying you don't need to leave here today, make an immediate call and say, I got to have cyber liability insurance. We're still learning it. And I can tell you that it is available. If you Google cyber liability insurance, you're going to find companies that offer it. But what we're going to have to figure out is that when you're looking for coverage, what do I have to have? What should I look at? And a couple of options relate to information security, privacy liability, those GA recipients that had their HIPAA stuff taken or stolen or hacked, those regulatory defense and penalties, a fancy way of saying, oh man, someone hacked me, and now all of a sudden I'm responsible for federal and state regulatory agencies and the penalties that come related to that. I didn't do it on purpose. Somebody got into my stuff. See if you've got insurance coverage for that, because that's going to be those options. It's still very cloudy right now, but we're in the process of figuring it out. So you have, we're over, but we'll have a couple questions. I saw there was still a hand. Go ahead.
I had a question about electronics at a meeting.
Mm-hmm.
And I've gone to another organization, not a government body, and if we're going to keep our phone or iPad or computer at the meeting, it gets registered with the agenda in case there is some complaint or, we're a realtor organization and sometimes we get complaints from members or whatever. Is that a policy that you would suggest for a township? I have trustees who, have their computers or their iPads on the table during the meeting.
So do I. I have one on my meeting, on my table. If you're going green, that's a good thing. If you have a big, I typically have between 150 and 300 page board packet, and I don't want to print it, and nor should I print it at my house or place of employment because I don't think my boss would like that. However, there's no strict policy per se on forbidding it. What I would recommend is that you all reconsider the idea of having your public officials at least say, hey, I'm going to comply with a policy that says I respect the idea of having electronic communications. I'm not going to use it to communicate with my fellow board members outside the scope of what's being debated and deliberated at the meeting. I'm not going to surf inappropriate materials while I'm sitting around that table. Quite frankly, shouldn't anyway. But I don't think that the stricter you get, I think sometimes it has maybe the opposite effect of what you're trying to get. I'm not going to say someone shouldn't embrace technology. I'm going to say that you should do it in a respectful manner. Yes?
On website, seems like at one of them meeting a couple of years ago, they said that you only had a short time before you had to have your minutes and so forth if you had a website, is that still okay?
Yeah, I don't have the section in front of me, but I think the Open Meetings Act talks about the idea that if you have a fully functioning website, maybe it's someone's full-time maintenance over, right? Right, you got to have someone full-time working on it. You got to have it posted under X number of days, maybe 30 or
But
60.
you don't have somebody full-time working on it, does it?
Depending on what the statute still says, you probably are okay. All right, guys. Well, thank you very much. Have a good day.